add that to our table of allowed uses, or it could be, we like the structure and we need to really go through this and, make sure it fits in with the ordinance. But I think the idea is, why do we have all this, like, what, public, commercial, residential, when you shouldn't have the categories broken out that way? You should just have a list. This is our table of allowed uses, and it doesn't need to be categorized by any particular overarching thing, so that, for example, you have a situation where. Well, I'll give you one that I was involved with, but you have the Land and Garden Preserve coming in to do their office space and shop, and we all know it's an office space, and we all know it's a shop, but it isn't commercial, so it doesn't really fit in the ordinance. But we could have a situation here where it actually does just sort of fit in.
Right.
So the exercise that we would be going through is basically like, A, does this sort of structure make sense? And if it doesn't, and you don't like it, then we don't have to talk about it anymore. And if it does, then we should be going through this ordinance structure and trying to figure out these terms. Some of these terms are ones that are already in the ordinance, and some of them are new. And the reason that they're new is because I just didn't want to miss anything. And so we would want to go through it and say, you know what, we don't like piggery because we think animal husbandry is just fine. Right, so we could just eliminate that. And if we say, oh, wow, we didn't realize that, I kind of like this idea of an assisted living facility, then we're gonna want to figure out which zones that assisted living facilities should belong in. And then my other question would be, well, do we have a term already? Like if I came to Kim and said, hey, I want to build an assisted living facility, is that even a term that we could permit in this town?
Right. Right.
So I think that's the exercise we should be going through.
And so if we decide we wanna go down this, I'm gonna say this possibly rabbit hole, we would need to be proposing the X's and CEOs.
Yeah,
For the new,
correct.
and the C's for the new,
Yeah, for any new term.
right,
How do you, I guess, because I am thinking specifically of that situation where I thought it was gonna be more of an issue of defining what nonprofit is, because, but as I'm thinking about it, when is a garage, like a big building for storage, it seems to me that it would be much different if somebody has an abundance of toys and they wanna have a large toy box on their property, as opposed to the exact same thing that for a commercial business. You know, if they wanna put up a storage building or a business that's running stuff in and out all day long, as opposed to somebody who has 12 Porsches and just wants them uncovered. You know?
I only have one.
I knew that was coming.
I do have a world full of people with an abundance of vehicles. And I can think of a few toy boxes around.
So I'm trying to understand, what, is there an issue with, if there's a land use difference in a regulatory sense
Yeah,
between a
yeah.
commercial garage and just having a building that you store your, like a personal garage? There's a lot of land use differences.
Yeah,
Not one is worse than the other. I'm just, the things that you would want to consider in a commercial, or sort of say like even a green rock type setting are different, traffic flow, lighting, those kinds of, different in the commercial sense, because you're in and out with different kinds of traffic and different kinds of businesses, but in in Alan's Porsche garage,
Right.
like that's just a big building on your property.
So if, I guess it came up over the Green Rock building. So if we were applying this to that, what we got caught up with is whether it was commercial or not, that we were gonna deal with it differently
Yeah,
if it was not commercial or if it was, and that we didn't define nonprofits,
right.
which it seemed to me that I just thought nonprofits are taking in money and they're giving out services that they may not make profit off of it, but they're exactly.
Yeah.
I felt the public comes to them, that it should be categorized as the same as commercial.
Yep.
so it's like residential or not.
Yes.
Yeah.
Non-residential.
basically.
And I guess that was the biggest thing,
Mhm.
because that would be exactly a situation where Green Rock comes and wants to. We've got the use of the land, but it is a garage that they store their maintenance equipment in,
Right,
different from. Do they have to be on commercial property then?
no, because I think the nonprofit status is just a status of ownership. It doesn't have anything to do with the use of the property. The use of the property is the same as a garage, like their use is the same use as anybody's commercial garage. You're just saying this is a for-profit business. It's the same use.
Right,
So
Well, one might say that there's a difference in that the access to that property and the purposes for which people would use those facilities is different than somebody opening themselves up to the public and advertising in the paper and saying, bring your vehicle over and we'll do a tune and lube, as
Sure.
opposed to maintaining. I mean, there is a difference. I mean, it's somewhere between, in terms of the extent of the usage, it's somewhere between private normally and commercial.
But what's the difference between that and if I opened up a small landscape business and did the same exact operation out of there? It's not, it's the same use of the property. It's
Sure.
just I'm owned by commercial or a nonprofit entity.
Yeah, I think you're closer to commercial certainly than,
you
Right.
get, I mean, if you were at the actual construction of the building, you have different fire codes and different construction. Because you have the public going in and out of the building,
Mhm.
As opposed to. If it was personal, which is, allows a level of.
Right, But that doesn't-
Recognition that, the risk is your own, you don't need to make sure that
Mhm.
wheelchair access.
Movers.
No,
That has nothing to do with nonprofit ownership of.
it doesn't,
It's all
but
about the use of that building.
we didn't get through it seems to me that in that discussion of the office and storage and everything, and whether it was commercial, non-residential. The way you talk about it seems like it should have been really straightforward, and I don't recall it being so straightforward.
I thought it was pretty straightforward, like here's what the thing that we would, it's because there's no nonprofit ownership, that's what gets confusing in the ordinance, but it's exactly the same
it's, yeah,
as services 3.
it's
or two.
consistent with allowed uses.
Yeah.
Other allowed uses.
So I like maybe the term residential or non-residential makes it easier, because then, yes, this is clearly non-residential, you have categories of that type of non-residential use.
Well, that's why it's worth at this point in time. Kicking the tires on that and seeing over
Yep.
time what we come up with, whether we come up with. Enough reasons why it's not that simple, and then we have to go back to the drawing board,
Right.
but.
We actually did talk to Andy about adopting the term called nonprofit, and it was. We dropped it because of the term nonprofit is it's a form of ownership, it's not a use
Right.
category,
We need to see your tax.
which I agree, I do think that's true, yeah.
So,
So it does, I mean, again, it doesn't matter if I'm a nonprofit or a for-profit, you're using this facility for the same thing.
right,
To what scale you're using it for, we could define in the ordinance, like some scales of a certain thing could use a different review.
right.
And some scales might not need to be as intense or whatever.
I mean, a lot of your definitions have different sizes. in
Yep.
it, large this, small that,
Right,
venues. And you can, that might be a way to do
And
that
this-
too.
this right here is not perfect, it was really just a place to start.
Right.
So if you wanted to, like, when I say, hey, we should really consider making an allowed uses table that's that's like. A table of allowed uses and not like categories of allowed uses under certain things. This is what I'm talking about, and the only way I could think to have a broader discussion about it was to put. The way that we have it structured, to put the terms. In there, the way that we have it structured, and to add new things that we might want to consider. As allowed uses, so it's really just a draft, and some of this you're gonna be like. What, again, I'll use the piggery one, like why
Right.
piggery? It's ridiculous, but it was a term.
I can see agriculture figuring.
Oh,
that's okay.
Yeah,
Oh,
piggery.
piggery.
It's like,
But I mean, again, it may not apply here, or it may.
It's
and
like,
we
why
may-
not
may really
piggery?
like animal husbandry because it applies to a lot of broader things, more comfortable with that term,
right,
totally fine.
right,
I'm just using this as, these are discussion points.
Yep,
And you should be asking the question like, well, wait a minute, when you talk about, we just got into this commercial nonprofit discussion, but I see in here you have an agriculture product processing commercial scale. Well, what does that mean? Well, there may be a defined term here. So what I tried to do is use defined terms
right,
and that those things in yellow so that you could see like, okay, well, if we decided we wanted to do this is the kind of term that would be.
right,
But none of it is set in stone. And it's really only, these two documents just kind of work together so you can understand like what does this term mean to the town?
yeah, we actually don't, I don't think we do have it.
We don't, actually, I was reading through it again and I think we missed that term and then there was another term. I actually had it printed off. I mean, I had it off to the side, but I had some trouble with my printer after I did these things, so.
Okay, so we're going to do that.
But we would go through this and say, okay, well, we can't, there may be some definitions that we need to add just for conversation purposes. Some of this we're just gonna delete and say this is dumb. I don't know why you didn't put this in here. This is great. I never even thought of this. That's the kind of conversation I envision.
So our homework assignment, it seems to me, for next time is
Yes.
to try to enjoy yourself. Working your way through this and take
Yeah.
lots of notes about what I started my list.
That's something I knew you would.
And then have us. Figure out if that's what we wanna do, if we wanna start chunking it up and going through sections of it.
Yep. And I would ask you too, Kim, sorry to interrupt, but like,
Yeah.
as you're thinking about this, if you have like a minute, well, I'm sure you don't, but like, there's a bunch of terms in here. There may be some terms in here where you're like, oh, man. Or in your brain, in your mind, you're like, I've had this issue and somebody came to me with this question about an application and I wish we had had a term for that, maybe it's in here. So that's something that we should,
Right,
I think that would be really helpful, because you know how it is in Reserve, like, it's the one town I work in that. If there's gonna be a question about something. You never thought you were gonna have a question about
I
it.
think a lot of these in here that I see, like movie theater and,
Mhm.
a bar, and it depends on trying to keep the quaintness and uniqueness of the
Yeah.
town and not have this, so you don't want to make it a big commercial city, town.
So you have X's all over through there.
What, huh?
So you put X's all over through there.
Yep.
We've considered it and the answer is no.
Yeah.
Right, and I think.
Or only in this district.
If it's not on this list, it's not allowed. That's the other way.
That's, yeah,
That's the way to think about an allowed use table. So if you don't want it, anywhere in town, you wouldn't put it on the list, right?
okay, that's not the way to do it.
So
And
if
then-
it's not on the list, it would be not an allowed use and you'd have to go to town meeting to add it.
Right.
Or you go to planning board to see if it's a similar use.
Sure, but I would say, like, if you say, we're not really comfortable with movie theaters, or you know what, we actually like movie theaters, but we want to. Define the scale of a movie theater, which we would allow, then we could make a definition that meets that scale.
I mean, you could also put in the ordinance a position that if it's not in here, it's not allowed, and that, then you don't get to go to the planning board, you have to go to.
That's right, that's the way I.
Yeah.
there
Otherwise,
a
the
plan
planning board is
if the-
freestyling.
If the issue of the quarry goes away, that we dump the quarry ordinance.
I think that I totally avoid the quarry ordinance.
Yeah.
Until that all gets straightened out. And
Well,
then-
I said, if that is all settled out,
Then-
would it be presumable that we would flush the quarry ordinance?
Depending on how it gets
Flushed out.
flushed out.
Yeah.
Well,
But
yes.
eventually you're gonna wanna delete at least half the quarry ordinance and then just keep the one half, depending on the outcome of that whole thing.
Mhm.
And you could also like make it better.
No.
Or just
Then we can think.
try not to do that. There you go.
Just a question, just a hypothetical question.
Anybody
You could-
else have anything they wanna offer on this discussion?
Does that make sense to everybody? I mean, like, I know it's fun to read through definitions and stuff, but it really is important, like, to think about, okay, yeah, these are interesting terms. And even if you would revert back to, like, we like the structure that we have, there may be some uses in here that we want to add to the current structure. So I think it's a worthwhile exercise. And then I would still think about scale, like Kim is saying, like, some of this stuff may not be what you're thinking it is, and we can just work on I like that, but I wanna tweak it a little bit, kind of thing. I think it'll be an interesting exercise.
I see there's no airports on there.
Nope, probably not.
You wanna make a motion?
Art
Would
galleries?
this also be something you
Yeah, there
want
may be some
townspeople to have a say in and not just a committee like us?
Yes.
So
Yes,
how would you get that out to the people?
all of this is predicated on the notion that as we go through the year. But as I understand it, we're gonna try to have numerous, not so much hearings in a formal sense, but as we're working through this stuff, say. Hey, we've been working on, you make it a public effort to say, hey, we've been working on this stuff and we'd love to hear people's thoughts about it. And we're gonna make sure that our agenda for X or Y has a lot of space for people to come and talk to us. And give us your thoughts about it, help us improve it or, and then get to public hearings earlier in the season than at the end, than before the last minute. But that's it. I don't entirely understand the proposal for that, how it's different than a public hearing, but. It's more like a workshop, you know, it's a,
Public hearings are, you shall do this.
Like
Yeah.
like an outreach.
Yes.
yeah, well, yeah,
I think at the end of the day, usually, we don't typically operate this way, but the public hearing at the end of the day is really just. Because of the timing of certain things, it's
Mhm.
basically, here it is, and then you get to hear from the public, but you don't build in flexibility to actually make good decisions based on feedback you get from the public, so you have
correct, so you want
to
to
plan
do
for like a public workshop on, that's why they're two different terms. One's more legal and one's like more flexible, I think.
You have somebody sit down with a. Report from the islander and have them do a piece about what the board is thinking, I mean, there's lots of different ways to do
Yep.
it, and then get the word out in various ways.
Yeah, because I feel like what commonly happens is you try to hold those workshops, and everybody doesn't show up, and then they throw, I mean.
Yep.
There have been a number of issues that, a little concentrated group, they said it was open to the public didn't. See it as a hot issue, they had better things to do with their evenings.
Right, and then last
goes to
minute
vote,
when they show up.
And everybody shows up and goes, what the
Yeah.
hell did you do to the slide? We don't like that idea.
Well,
Yeah,
I
it's
think
how
there's a certain amount of
That's how
that.
government works, unfortunately.
Yeah.
That's why you don't have lots of people on committees. I mean, average person would rather stay home and eat dinner.
So to answer your question, Kim, I don't think that we're gonna, it would be an ineffective public meeting to go out and say, hey, we're getting ready to change the allowed uses table. What do you think? I think we need to do some work as a committee, as a planning board and a land use committee and say, we're thinking about changing the structure. Here's what we've come up with, and then try to create some questions that we want feedback from the public on.
Right,
Here's why we're doing it, right, the reason, the process we went through, these are some things that we added that are new, we could explain it all. And then give people the time to look through it and say, why did you not include this? Because I mean, I find oftentimes. We do get a lot of good comments that
right,
we just aren't gonna be able to do, but I don't think we wanna go to it and with a broad question, I think we wanna say, here's this. We've done all these things, what do you think? Are we missing anything?
right.
Yeah, why is this here, you know?
We couldn't figure out how to do this, what do you think, or whatever, yeah.
Yes, so it's a more facilitated discussion and not a.
And there's no guarantee that it's gonna work, but you put that effort into trying to get people.
Yeah. Hey, we've got a member of the public here already tonight. Read through it, but always good comments. Like,
Alright.
I've never been to a meeting where we haven't had good comments,
Okay.
so. Anyway, so let's build that into the process.
Yep.
I think, maybe I would make a suggestion that we want to amend our work plan. I was thinking about this too, so if we're gonna come back to this. Next month, we were supposed to talk about potentially subdivision and site plan. I think I'd like to kind of flip June and July around a little bit and talk about solar ordinance. There's not a lot of, we can go over legislation and then maybe dive back into this.
So do the solar ordinance in June?
June.
Is the Climate to Thrive still working on that?
They have a draft that we have, which we're gonna review. Yep. So I have to reach back out to them. The person that was working on it left, and now there's a new person, and I'm just coordinating with them.
So before we do that though,
Anyway,
we are on, if we're done with this. Then my suggestion is that we go on and have a conversation about compatibility, and I'm so happy to see other members of the planning board here, because they did raise this subject. At the last planning board meeting, and then we had a good back and forth with some specific perspectives on compatibility. And 6A, that section. So. No.
yes,
Do you want to start by do you feel comfortable starting by making the case for the either elimination or alteration or the integration of the compatibility concepts into other more articulable portions of the zoning ordinance?
Let's see, I don't know if it's not really a suggestion. It is, the question before you is what you just articulated. Which is 6A is a very subjective standard. And the question I would ask is, are there better ways to deal with, to address the things that 6A is trying to get at,
6A1.
6A1?
Yes.
Yep, using either other places in the ordinance, so are there other places in the ordinance that already address the things that are being asked in 6A1? Or do we need to add some standards to other places in the ordinance to get to those standards? And the idea is, the reasoning would be that 6A tends to be a pretty subjective review process. And it really isn't based on a set of standards that is similar to other sections of the ordinance.
So to remind people who are here, 6A1. There are 6A is general performance standards, and it has a great deal, it has a whole bunch of them. It has highway safety, impact on town services, lighting, erosion and sedimentation control, on and on and on and on, that you have to go through for every application that comes before the planning board. And then at the top of all of that, and each of those have specific standards, and on the top of all that, there's compatibility, which stands alone at the top of 6A, and it reads in full: the proposed use shall be compatible with the permitted uses within the district in which it is located, as measured in terms of its physical size, visual impact, proximity to other structures, and density of development. Period, that's it. So the question is, how does that interact, and to what purpose and use is that put in the deciding on the appropriateness of an application that's before the planning board? And there's a significant divergence of opinions about how that sort of thing, and indeed what the role of the planning board is. And I would welcome just a chance for people to express some of their varying perspectives on what that is and the value of 6A1. So who would like to go first?
Well, that's the only section that's got any description as far as building size. You know, how can you see it, you know, relative to the road, to the property lines?
Mhm.
You know, I mean, I have to look at the same standards when I issue permits.
Yeah.
And I always have to make sure, you know, accessory buildings don't supersede the primary principal building. So I look at size relative to size. But it's kind of hard with the planning board because, I guess, because if somebody wants to do like animal husbandry, just we'll use that as an example. And it has to come to you for conditional use, but they want to put up a chicken coop or something like that,
Mhm.
or. You know, have horses or whatever, you guys gotta look at that use. And the structure, the use of the land,
Mhm.
area of the land used for that, you know, that use. I mean, that's the only area that talks about size. You know, and if it's a permitted use. You know, you allow it with the standards, you know, that you have to follow 6A, B, and C.
Mhm. And we do not have a design review process.
We don't.
So. Some areas, like some areas in Bar Harbor have that, I don't know whether we want to get, I mean, that's one possible way to address that, but
I don't think you wanna create a committee for
I don't
aesthetics.
personally am not proposing
Tell
that.
somebody what color their building can be.
Well, you know, I had that discussion with you, well, I had that discussion with
Yeah.
myself,
Right.
and I don't think hopefully many people do. And. But what do other people think about this?
I think it's nice that we have something that if something comes up that's just so bizarre. You know, we can just say it's just not compatible with the neighborhood. And it gives us kind of broad jurisdiction. To. If something is just too weird. You know, we can. Call them on it. You know, generally speaking, you know, most things. I think it's rare that we'll have to use that. But it's nice to have something.
Triangular building, which town is that in? The
What's
one
that?
You know, Kippy Stroud's building that's,
It's in Bar Harbor.
is it in Bar Harbor?
Yeah,
I mean, that-
painted with clouds and, yeah, yeah.
Yeah,
So that would be a,
But what might
that's an
be
apron.
not bizarre
Right,
to
yeah.
them is bizarre to us and vice versa. I mean, how do you,
I mean, weird is
judgment.
not
I
much of a
mean,
legal
well,
standard.
no, but I mean, yeah,
Yeah.
I mean, people have, you know, interesting tastes and architects have introduced designs and.
Yeah.
Many years ago, somebody. Bought an old boat. And buried it to the water line. Next to somebody's house that I knew. And that I would think would be a good case of not being. Fitting in with the neighborhood. It was an actual boat.
I don't know, was it a shoreline?
It,
Well, and it would depend on whether it was visible, somebody has, you know,
it
they
was,
can stick in the middle of a lot where
yep,
everybody else.
totally visible. It's just normal house, normal house, normal house. A boat.
Yeah.
And you know, like I said, they buried it right to the water line, so it was like it was sitting in the water. And then that.
My feeling is that anytime that you set up, you try to figure out the criteria by, in this meeting already, we've sort of talked about the need to. I think people in town have some right to have a sense of predictability when they invest in owning property and what the neighborhood is around them, which the code gives them. And there's some interests of maintaining character or whatever in a town. You can try to create a list of that the ordinance does, but inevitably somebody always finds a loophole. There's always something that breaches what the intent of the ordinance is. And that's why I think this section is really important. It has at times delayed, it caused longer discussion than everybody desired, but I guess I don't think that it's a problem to allow people to express their ideas. I still think that the outcome was the same. It may have taken painfully long to get there, listening to everybody who used this section to express their views, but their views were their views and they got it out. So I think it's a good section. And I also will point out that part of what's driving this is to try to stop people from coming and just saying, I don't like what's being done and I don't have any thing in the ordinance, is that this issue is something that's been brought up to the planning board. And my feeling is the planning board repeatedly has said, and Kim has said, this is an important section of the ordinance, but we're allowing you guys to repeatedly bring it up and up and up. And you're the ones that are being allowed to express your opinion and we're listening to you. And it's not being shut down, even though pretty much you've been told by the planning board repeatedly that this is an important part, that we use this section and we feel it's an important part of the planning of our ordinance.
Who else has thoughts about this? I do have thoughts about this. I think that our obligation as a planning board, which is different than our obligation as committee members here, is to enact and interpret the ordinances that the town passes at town meeting. And I think that in as much as possible, we need to seek clarity from the town and from the voters about what it is that they expect us to be enforcing. And that we should not seek to freestyle as individuals who are planning board members any more than we have to. And while I think it's our responsibility to conduct the deliberations in a mutually respectful fashion, I don't think it's our responsibility to use this ordinance to, there's a social work tool, essentially, it's like to bring the parties together and like, because, well, first of all, frankly, it didn't, in the situation you're alluding to, it actually hasn't worked. You're in Superior Court, but that aside, I just don't, I think that we have to be careful because we're not individuals who are wielding power. We are individuals who are trying to do what the town has told us we should be doing and not doing. So I'm always uncomfortable when we get in a situation and say, well, yeah, and I know it meets all the provisions of 6A 2, 3, 4, 5, 6, but I don't know, it just doesn't, to me, it just looks a little off. It looks weird. I'm uncomfortable with that, and I would sooner see us trying to figure out, if we have concerns about physical size, visual impact, proximity of the structures, I think those are all valid concerns, but can we not do a better job integrating those into specific standards and specific definitions, than leaving it? I'm sure it's not void for vagueness legally, but leaving it so vague. I don't think it, and I also don't think it serves the applicant that well, who is also our client, and the applicant comes to us having put a lot of effort into a plan, no matter what the plan is, and they need to have some ability to understand what it is their obligations are when they bring something to us. So that's my 2.5 cents worth on whether or not we should move 6A into other parts of the ordinance. I think it's a worthwhile effort to try, and if we don't get there, we don't get there. But I personally think it's a worthwhile effort. I'd love to know if other people have any perspectives on it. I mean, you have 4 planning board members here.
I was gonna say, you all are so much more familiar with this ordinance
Yeah,
than I am, and
Yeah.
I don't know about Chuck, but you know the hurdles and the stumbles and the challenges you felt. So,
right,
it's hard for me to comment on those things.
right. I mean, I'm not arguing that those concepts are not important. I'm just concerned about them being left to interpret however a particular planning board feels it wants to interpret them. That's all. Is there a way we can provide better clarity for both applicants and abutters and the community as a whole? Can we, but by we, I mean, can the town do a better job articulating that?
Not quite sure how we would write that in.
Well, you take. I'm not sure off the top of my head either, but you take those terms, I mean, you say you're not sure about writing it, but how are you then sure how to interpret it? When you're sitting here at a planning board meeting and there's a proposal that has, a visual impact question, how do you interpret it then, on the spot?
I would think that generally speaking, 99.99% of the time, we would not say that something's not in with a neighborhood. It would take an awful lot, and it would take something strange. And it'd be good to have something that we can say that we don't agree with, having something like that. I know that is somewhat not right. We all should be able to do what we want to do. But
Well, I wouldn't argue that, but, I mean, it's part of living in society that we make accommodations to one another's but.
yes,
But I still not sure what the difference is between trying to articulate it in a more comprehensible way in the ordinance versus just coming up against it in the middle of a meeting and saying,
and I would,
you know, you get into density of development. I mean, there was obviously a big dispute, is. If something is perceived to be too dense, but in other sections of the ordinance, it seems to not be too dense, arguably. Why then do you have that provision there that allows you to say, well, it may be that in these other specific provisions that it complies, but we still think it's too dense?
You work in a lot of different towns, do you see this in ordinances?
Nope.
That you work in? No.
I mean, I think about it in a few different ways, and I can appreciate that the planning board having a way to be like friendly and communicative as an application process goes through, and that's always appreciated. I think that one of the things that I look at is there are other places, so if you just take the example of density of development, like theoretically, the town has already decided that this particular area has a particular density that the town wants it to have.
Right.
Just because it doesn't have that density today, doesn't mean that's not how the town wants it to be in the future. That's why you created zones with minimum lot sizes and other things. So that has already been decided. So, but what this does is gives the planning board the ability to overrule what the town already decided when they created a particular zone, because that density doesn't exist today. See what I'm saying?
Yeah.
So that, in and of itself is an issue. So I think that on principle, the town should decide, like, we want this area to be zoned this way, and these are the allowed uses, and this is the density. That happens on a much broader scale. It's a town-wide scale. It's a town meeting discussion. It's a public meeting, public hearings. And that's how it happens. It doesn't happen at the planning board level. If you were an applicant, you wouldn't go to the planning board if you didn't think that that particular thing was an allowed use in the same way that you just wouldn't even be able to get on the agenda. And I also think that things like proximity to other structures, again, you already have setback standards for structures. So what is, now you're saying again, if you were to deny something based on compatibility for that particular standard, then you're negating another standard that's already in the ordinance. Like, so wait, just because all the other structures in this district aren't that close, but your ordinance says that you can be that close, now you're telling me I can't be that close because it's not compatible? I don't understand. So I'm trying to avoid, like, those questions will pop up. The visual impact assessment stuff, I really think that's kind of an eye of the beholder question. So we should maybe try to slog through, and I'm not advocating for a design review committee. Do not, that's not what I'm advocating for, because I think that just adds a whole nother layer, and it's for a wholly different purpose. But what are the standards that the planning board should be asking an applicant to look at, or if I'm an applicant, what standards does the town think that I should be looking at if I'm gonna come to you? It just makes more sense to do it upfront. It's way easier for everybody. And it is not an issue of being in control, and this is not like some thing that the town needs to just start creating all these standards, but there might be a better way to do it than in this particular application. I think physical size is another one, like, so you have lot area requirements. What is too small for you? What is too big? What if we wanted to do a bunch of tiny homes and all of a sudden I want to do a tiny home on my property and it's not the same as all these other bigger homes around me? Now that's not compatible. So it works in the opposite way too. It is not always just like a bigger house. It could be a smaller house. And we do want to allow those. We've already said we want to allow those. So I think that those standards are better suited in different locations in the ordinance, and that you should have a discussion about what do you mean by these things, so that you're not in a position of unknowns. That's just my opinion about it. But I've said that before.
So 680
Happy to
should be
deal.
removed.
What?
6A1 should be removed?
I would not, I mean, I understand the principle of it, and I understand the flexibility of it, I just think that we should spend more time thinking about what we mean by those standards and either integrate them better into other sections of the ordinance that deal with setbacks or lot sizes or whatever, is it? Than to have.
But
it-
it's already addressed under your dimensional requirements.
Yep.
So it's kind of redundant in a way,
And
isn't
I
it?
would either, that's my thought, but I'm not the one that gets to decide those things.
And that
Just my-
doesn't in any way, like you remove that or integrate it into the sections, you're not in any way stifling public comment on any of those topics. That doesn't change the public's ability to come in and say, instead of under 6A1, say 6B, whatever.
Yep.
I have an issue with the setback requirements here. I mean, you certainly have. You're not changing the public's, I don't see how you're changing the public's right to engage in a conversation about a particular application that they feel is troubling to them in some way.
I just don't know what you mean by.
Cause otherwise you're just trying to what you're trying to do is get the planning board to exceed or deviate from the specific standards that the planning or the LUZO has. That's, and again, that's my
would
take.
just like to say that I've heard both of you guys say all of these arguments repeatedly.
Mhm.
And I still can think, or just feel that there have been plenty of situations where it's basically, you try to create, criteria that everything is compatible. But as soon as you set up a rigid structure like that, there are things that just they aren't compatible despite the fact that you created this criteria. And that this is the section that kind of allows for recognition of discussing the specifics of the uniqueness of each project. In the same criteria as we have this specifics, but at most of the time, 95% of the time that we use this section, it's for discussion. It's not that the rest of it's, do you actually fit the specific black and white criteria? And this section allows us to have a conversation about whether you're actually being compatible with your neighbors and whether it makes sense. I also think the ordinance is generally sort of designed to like, what is this criteria? What would be the maximum area that you want to cover? What would be the maximum height, like that you wouldn't want to do all of those things. And we're seeing more and more people coming and saying, I bought a lot and I want to max it out, just max how tall, how wide, and I just max it out. And I don't feel like the code is generally when people wrote the code, that they were thinking that that's what people are gonna come and do, is just max the code out. And I feel like, I just have found over the 8 years that this is the section that we have real conversation. And have changed plans, not because we told people that they couldn't do things. Because if you leave it to a black and white criteria, there is no conversation to be had. They either achieve that criteria or they either achieve the standard or not. This is the one section where people could say, yes, your building is allowed to be 20 feet from my building, but have you noticed that we're both on 3 acres lots and there's nothing else around? Would you mind moving it a bit farther away just out of consideration? And they say, oh, is that right? We'll just, like, people, you even objected to people, Gail, and coming and saying, would you mind putting more vegetation? And you said, you shouldn't do that. I'm like, that happens all the time, and I think our community is stronger for it.
But I don't think I was concerned about that because the planning board should not be issuing conditions on use permits that the planning board can't or doesn't enforce. And that was not enforceable. I mean, it was, and so I think that's the tough part of a planning board's job. You either do it according to the ordinance that the voters have passed, or I don't need to repeat myself anymore. I mean, I think Or you don't kind of freestyle as a board on how to interpret things.
But when you got people that are agreeable, what's the big deal, really?
Why can't you ask them that at a
Yes.
planning board meeting without the hammer of that
Yeah.
Yes,
particular
I-
section and then? have people be
It's
agreeing to it?
my projects get shot down. Everything I bring to the planning board gets shot down. And I will tell you that I don't know what my problem is, but one of the things that got shut down. Followed the criteria, filled out, thought this is a no-brainer, this is the easiest application, we're changing the use. And showed up for the site meeting and the villagers had shown up with their pitchforks. I mean, completely blindsided, had no idea anybody was upset about anything. And it turned out it was an old issue that they were holding against the new owners and refused to let them do it. And it was pretty much just that they wanted to be mean because they were upset about.
So wait a minute, did the
Previous
planning board
They had to-
not allow it to have it happen?
Yeah.
And she withdrew it.
I had to
She
spend-
withdrew it.
And you think that's okay?
They were following the code, it wasn't on this section, but you can't predict, and it was unfortunate because I think it was an opportunity.
It was
for-
on section 6A1 too, that had something to do with it.
It was a change of use because the corner of the building set over the setback, so the
Oh,
previous
I was
owner.
thinking of, no, I was thinking of the one when you.
The other one
Yeah.
got shot down.
Yeah. That was the compatibility, that was that one. Do you remember that one?
The first one right before I came on the planning board was wanting to build an office.
Yes.
And that I never, as I've been on the planning board, I've why did that get shot down?
But it did.
Well, I don't think
And
they
it
make
was
a good
based on
argument for the
compatibility.
decision, but that's.
Well, so as the person who's the
On the
victim
receiving
of
end,
this, I
yeah.
am still saying, I think this is an important section. Regardless, I know it's the way that you think, Gail, and you've got experience, but I have all these years of experience on the planning board and we use that section, and it's been really beneficial in many, many, many situations to us, and I understand what you guys think, but I don't think that it's damaging to have this section. I can understand why it's a little confusing, but and the one thing that you're saying, it went to court, it didn't go to court on this one section. God knows.
Right, but what I would say is this,
We're
I have
able
no
to-
problem having these discussions at planning board meetings. But what I'm concerned about is the planning board making decisions based upon these issues, even that are contrary to, like in the situations you're describing, that are contrary to specific provisions in the ordinance. You always, in my experience, if you have specific provisions that the lawmakers, which are the town voters, have passed, then those are the ones that apply.
That's the only
And-
thing that we really, when it comes down to it, we all know that those are the ones that we really are upholding. The other things are things that we're trying to encourage people, but our decisions are always based on the facts in the ordinance, not.
But, okay, so where do we wanna leave this issue for now? I mean, we can put it back on the agenda, we can continue discussing it. Ultimately, I think that the committee ought to make some, oops, jeez.
I
No,
think
it's
it's
not.
okay as written. It leaves it, vague, and I think
Yeah.
there's 1 in a million chance we need to have something that's vague that we can utilize if we need to. Hopefully, we'll never have to, say anything, because
I'm not sure, Andy, you wanna have Andy's opinions on that?
We already know that.
I mean, I
What
just,
I would say is this, having sat in enough planning board meetings, not with the form in front of me, not with an application filled out, but sitting there. It always feels to me when I'm in the audience that you all are reading this for the very first time. That you're not versed on it, you don't understand how to answer it. Well, what do you think? You think we should do this? Do you think we should? It's just like, you all don't know what's going on, and this poor applicant has come to you for your blessing, and you don't know which way is up. That's my interpretation of this section from sitting in the cheap seats without it in front of me. I just feel that Maybe it needs to be more simple, maybe it needs to be less wordy, maybe it needs to be filled out in a different format. But it's not building confidence as a person that's sitting in the audience, that you all know what you're doing with this section. And I don't mean that insulting, but I know it sounded that way, but really, I didn't mean that. It just sounds like, it doesn't feel like you all know what you're up to.
I think it's all the loopholes that people will try to
Mhm.
jump through.
And if you provide them a giant loophole. That's, as in your own words, is vague, then that's what you're gonna get.
But this is closing the loopholes. This is, you try to write, somebody tries to write an ordinance that covers everything, you inevitably don't think of something. And this allows us to talk about it in more of an intent way. And I guess I feel like most of the time when we are waffling around on the planning board, it's because we don't understand which ordinance we're, whether it's an unconditional use or a non-conformity, or, it's the forms, it's the procedure that seems to flummox us, but I feel like this section, we just. And I guess because most of us aren't lawyers, so the whole finding of fact, conclusion of law is not normal everyday language, and we often stumble in every single section. We stumble as to how to word things, but that's just, we're not lawyers, it's, most of us aren't lawyers anyway. So the way of the language isn't fluid.
Mhm.
And I'm sure it does make us look like we don't know what we're doing, but I don't think this section is what's causing that. I think that's just.
It's long been my theory that whenever you're dealing with any sort of complicated structure like LUZOs or whatever it is, that there's a bureaucracy that's underneath it all, essentially. And that the quicker, if you're involved in interpreting and using it, the quicker you can become facile with the bureaucracy, then the more you're able to then deal with the substance when it comes before you. And I think that's what the planning board we could all get better at. You don't have to be a lawyer to do that. I mean, my experiences about that sort of thing come actually from being in district court and having 60 or 70 criminal cases to process in the morning and realize there's a big freaking bureaucracy underneath all of this, and I better become quick with it, and then or I'll sink. And once you do that, once you learn that, whatever the venue is, once you do that, then you can get to the meat of the matter much more efficiently when you're not having to struggle with what findings of fact and conclusions of law are. So there's ways for us to get, all of us to get better at that if we want to focus some attention on that. But that's something we can, maybe the planning board should discuss. But shall we, for the sake of today's discussion, which I hope has been useful, certainly brought out a lot of different important perspectives. Shall we leave this for now? Put it back on the agenda for further discussion. And I would hope that having heard this discussion, people who are on the committee will go away thinking about it and come back with some other questions or some other observations, or maybe some suggestions for how we can have our cake and eat it too, with respect to
It is on the list for our next meeting,
Right.
to recap on it.
okay, so let's leave that for now unless somebody objects to that. And we get to the point,
Can I just
Yeah.
ask a follow-up question?
yeah.
So again, just as your staff planner, I'm not gonna spend any time on this until you guys make a decision on whether or not we should spend time on
Okay,
it. Does that make sense?
yeah,
Okay.
I think it's fine as written. I don't know how we could. And we have everything else that we have to check off.
I would just ask,
And I
as
don't.
you're reading it, I would just ask
As a
yourself the
planner.
question. What do you mean by physical size? What do we mean by visual impact? What do we mean by proximity to other structures? What do we mean by density of development, and is that the place to answer those questions, or do we already answer them somewhere else?
The public
Isn't
has a
there better
right,
place to do that?
as much as possible, to have a governmental agency be able to articulate what it is expected of individuals who come before, apply and want to do something. And I think that's the purpose of all of this and why it gets to be so complicated, because we're trying to do that for people. And then if you say on top of it, I want to have something that is vague so that we can deal with weirdness. That's,
You have
That's
to
an
under-
issue.
you have got a difference of opinion, and I guess.
Yes,
that's what
we do.
I just like, I
Yeah.
understand you guys have a difference of opinion, but you keep saying the same things over and over again. And I guess it's just the like, understand that this is a difference of opinion, it's nobody's wrong here. But it isn't, it's a difference of opinion.
So in my mind, the question isn't like who's right or wrong, it's
Right.
like, do we want to spend, does the group want anybody to spend more time on coming up with an alternative solution that people can evaluate or not?
Done.
We don't have to decide that today, we can decide it, I think what you just figured out is let's talk about it next month, but we just haven't, we're not, I mean, I'm not spending any time on it,
Right.
I've already articulated my
Right.
position on it, but it's really doesn't matter what I think.
right. Okay. We all right with that for now? Okay. What we have is other items as needed. And I think unless anybody has any.
Nope.
So we're gonna talk about the solar ordinance next time?
I would propose that in our work plan, we had for the June meeting, we had potentially discussing subdivision and site plan review ordinances along with recapping the two things that we talked about today.
Mhm.
And that we flip June and July and spend June talking about the solar ordinance, which we could have a draft of. And if there's any legislative tweaks that we need to make based on the current most recent legislative session, of which the governor vetoed a bunch of bills, that probably would have had some effect on us. But we can go over that as well, along with
Okay.
any of this other lingering stuff.
Are we going, when we do the subdivision ordinance, do we anticipate being ready with any and all concerns that Andy's
So I
office
have already
had?
reached out to Andy and haven't heard back, which is another reason I kind of want to punt it down the line.
Okay,
Yes,
okay. Thank you. The next meeting is scheduled for, I'm gonna get that schedule in front of them,
June 18th.
June 18th. Same time.
I don't
And we
believe
should
so.
also put on the agenda for then, what to do about the chair. And we do need to discuss minutes, because independent of Jerry saying he wasn't gonna be here. Joe has asked that, he asked me if I would do minutes. Because he doesn't see himself able to come today and possibly in June, and he feels as though he hasn't actually been doing it anyway, so we should have a discussion about what. Taking minutes for this meeting would look like. And what we should be doing to make that happen, and who is willing to take one giant step forward to make that happen. All
Are
right,
these minutes recorded? I mean, are these meetings recorded?
yes,
Do they go up on the YouTube thing?
I
I think they might. I'll have to look,
I think they are.
yeah,
all right.
it's good, we can view them,
Pardon?
and we can view it.
It is sure good we can do it.
If it's raining really hard. All right, anything else? If not, we should adjourn.
Second that,
Well, I'm not.
I make a motion to adjourn.
Thanks, everyone.
We'll vote on something. Thank you.
You want to keep any of these things?